Some may be asking, what about the Fourth Amendment protection against warrantless searches? Does this not extend to U.S. citizens at the border? Actually, the courts have held there is something of a gray area at the border, which, by the way, includes international airports and seaports. Customs officials may conduct routine searches of luggage or other containers without a warrant, under what some refer to as the border search exception to the Fourth Amendment. This so-called exception has historically been used to ensure that no weapons, drugs, or other prohibited items, cargo, or persons are entering the country. I think that most Americans could agree that it's reasonable to let customs officials search suitcases for contraband. What's unreasonable is that the government lawyers want you to believe that there's no difference between a suitcase and a smartphone. I disagree, and here again I think most Americans would too. Physical contraband cannot enter the country unless it is smuggled in. But this is not the case for electronic property. Anything a Border Patrol agent can find in the contents of your cell phone could enter the country through the internet without the physical phone ever coming close to the U.S. But it is all the more troubling when you consider the government is gaining access to, what the government is gaining access to. Smartphones can reveal virtually everything about a person, their movements, habits, relationships, health, faith, finances, all in a single, easy-to-use, and archived interface. Indeed, I think for many of us today, searching our smartphone would prove to be much more intrusive than even a search of our homes. This same sentiment has been echoed in recent Supreme Court decisions regarding the Fourth Amendment and digital data. In a unanimous opinion in 2014 case involving cell phone searches incidental to arrest, Riley versus California, Chief Justice Roberts wrote, "Cell phones differ in both a quantitative and qualitative sense from other objects that a person may possess. Searching a person's smartphone or other electronic device is fundamentally different than searching their suitcase or their car. And I believe as legal challenges to these searches reach the Supreme Court, they will agree. We have an esteemed panel of witnesses here today who will discuss the history of border searches, the appropriateness of using this authority to search smartphones, and what actions Congress should take to address this issue. At this time, I'd like to recognize Ranking Member Peters for his opening remarks. Senator Peters.
Thank you, Mr. Chairman, for calling this hearing today. I appreciate your continued willingness to work in a bipartisan way to take on tough questions about our core values as Americans, our rights and responsibilities as citizens, and our role in the centuries-long fight to ensure equal protection under the laws. The problem we're exploring today requires us to examine detailed policy directives and puzzle over how 18th century words fit to a 21st century technology. The details are important, undoubtedly, but at its core, this hearing is about the liberties guaranteed to us by the Constitution. It is about our freedom to travel, our right to be secure against unreasonable search and seizure. It's about our right to be treated equally under the law without regard to race, national origin, or religion. The Fourth Amendment states clearly, and I quote from the amendment, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath and affirmation, and particularly describing the place to be searched and the persons or things to be seized," end of quote. U.S. Customs and Border Protection asserts that the Fourth Amendment does not require a CBP officer to obtain a warrant or even have individualized suspicion before searching a smartphone or directing travelers to unlock their devices for official inspection. Today's witnesses, like most of the courts that have considered this question, disagree. This issue is of particular significance to those of us who live in Michigan. Michigan shares hundreds of miles of international border with Ontario, Canada, including the Ambassador Bridge, one of North America's most busy border crossings. Most importantly, Michigan is home to a large and extremely vibrant and patriotic Arab and Muslim American community. And community leaders tell me that they feel unfairly targeted by the CBP. I've heard countless stories of my constituents returning from family vacations, medical conferences, work trips, you name it, and being singled out for additional screening, being required to turn over phones and computers, provide their passwords, and wait for hours while their devices are searched. Some constituents have reported being asked about their views on politics or foreign affairs. CBP says that travelers can file complaints if they feel that they have been mistreated. But my constituents fear that complaining will cause them further targeting. And who among us, tired from travel and eager to return home from family, won't feel very vulnerable in this situation? One of my constituents described his perceived targeting as a backdoor travel ban. The fear of unfair treatment and the profound inconvenience of repeated and prolonged searches creates an immense disincentive to travel. It hurts families. It impacts commerce. We can do better, and we have to do better. Under the Constitution, Arab and Muslim American citizens are entitled to the same liberty, the same privacy, and the same freedom of movement that I am entitled to. CBP plays an essential role in securing our future and protecting our national security. It is critical that they have the tools that they need to succeed, but it is no less critical that those tools adhere to the Constitution in their design and application, and that no law-abiding American is unfairly singled out. Just over the last few days, I have received several heartfelt letters describing unfair and unconstitutional treatment and asking for congressional intervention. Mr. Chairman, I ask the letters from the Arab American Institute, the Arab American Civil Rights League, the Arab American Anti-Discrimination Committee, and the Electronic Privacy Information Center be entered into record.
Without objection.
Congress should weigh in and establish clear constitutional rules and a means for ensuring that they are applied equitably. I am grateful that Senator Paul, with Senators Wyden, Leahy, and Daines, have taken the lead in identifying a path forward, and I hope this hearing goes a long ways in making that path available.
Thank you, Senator Peters. First, I'd like to begin by noting that we may have some senators who are not on this committee, and I would like to ask unanimous consent to allow them to fully participate in the hearing, provided members of the subcommittee be given deference in order of recognition. Next, I'd like to remind the witnesses that the written testimony they have submitted will be included in the record, and to keep your opening remarks to around 5 minutes. Let's begin. Laura Donahue is a professor of law at Georgetown Law and the director of Georgetown's Center on National Security and the Law, as well as the director of the Center on Privacy and Technology. She has written extensively on privacy, surveillance, national security, and emerging technologies, and enjoys the distinction of having been appointed as one of the 5 Friends of the Court to the U.S. Federal Intelligence Surveillance Court, positions which were newly created by the 2015 USA Freedom Act. I would also note that she serves as a reporter for the American Bar Association's Criminal Justice Section Task Force on border searches of electronic devices, so she is extraordinarily well-versed on the topic of the hearing today. Welcome, Professor Donahue.
Thank you very much. Chairman Paul, Ranking Member Peters, and members of the subcommittee, thank you for the opportunity to testify at today's hearing. The border search of electronic devices is rapidly increasing. In 2015, CBP examined 8,500 devices. The number more than doubled the following year, before soaring in 2017 to more than 30,000 searches. ICE, in turn, searched just over 4,400 cell phones in 2015. In 2016, it searched 23,000 devices. As Chairman Paul noted, the Supreme Court in Riley v. California recognized that these devices, quote, implicate privacy concerns far beyond those implicated by the search of a wallet or a purse, end quote. Even the term cell phone is misleading. The court noted many of these devices are in fact mini computers that happen to be used as a telephone. They have an immense storage capacity and can hold millions of pages of text, thousands of pictures, or hundreds of videos. In contrast, most people do not lug around every piece of mail they've received for the past several months, every picture they've taken, and every article or book that they have read. The type of information is different than that uncovered in a luggage search. Medical records, location information, political beliefs, religious convictions, and relationship details for decades. In fact, more information than can be ascertained from the search of your home. The executive branch is divided in how it addresses border searches. As Ranking Member Peters pointed out, CBP's January 2018 guidelines allow for searches without any suspicion whatsoever. This means that the executive branch could seize the phones, iPads, and laptops of every member of this committee, those of your staff, your spouses, and your children, whenever entering or leaving the United States without any suspicion of wrongdoing. There are no statutory limits on who can see this information, how long it can be kept, or how it can be used. And there is no special protection provided for sensitive material, political material, client attorney privilege, trade secrets, medical information, or materials otherwise privileged under the law. For advanced forensic searches, officers must merely meet a standard of reasonable suspicion of illegal activities or national security concerns. No probable cause is required. The equivalent immigration directive has not been updated since 2012. Like its counterpart, it pertains to any item containing electronic or digital information. But unlike its counterpart, ICE authorizes agents to search, detain, seize, retain, and share aliens' electronic devices and information with or without individualized suspicion. At any point during a border search, electronic devices or copies may be detained for further review, either on or off-site. They can be kept for 30 days and extended at 15-day intervals thereafter. CBP claims the plenary authority to conduct searches and inspections of persons and merchandise crossing our nation's borders. The government is right that this border search power derives from U.S. sovereignty. As I note in my written remarks, courts have for decades recognized that this power resides in Article I and Article II. But the founders did not end the Constitution there. The Constitution also protects rights. And as Chairman Paul recognized when he introduced the Protecting Data at the Border Act, innovation does not render the Fourth Amendment obsolete. The 3 Supreme Court cases now recognize the heightened privacy interests at stake. Riley dealt specifically with mobile telephones. In the 2012 case of the United States versus Jones, 5 justices, the so-called shadow majority, adopted the view that individuals have a reasonable expectation of privacy in the whole of their physical movements. This past month, the Carpenter Court built on Jones. Chief Justice Roberts, writing for the majority, looked at just one type of information that's located on mobile telephones, noting 6 elements that make it different from other kinds of records, namely that it's specific, it's retroactive, it's extensive, going back multiple years, it's precise, it's deeply revealing, and it's easy, cheap, and efficient to access. Mobile phone data is different in kind than other kinds of records, and it's different in kind than what we pack for a trip to, say, Australia. Lower courts, unclear about how to think about electronic border search post-Riley, Jones, and now Carpenter, are reaching disparate and deeply concerning conclusions. I'd be happy to discuss these further during the session. In addition to the Fourth Amendment issues, as I note in my written remarks, there are important First Amendment issues of freedom of speech and religion and association. There are Fifth Amendment self-incrimination and due process concerns, and there are Sixth Amendment right to counsel issues on the table. I look forward to the discussion. Thank you.
Thank you. Our next witness will be Nima Singh Guliani, who's a senior legislative counsel with the American Civil Liberties Union's Washington Legislative Office, specializing in surveillance, privacy, and national security issues. She was previously on staff at the Department of Homeland Security and Department of Agriculture, and I think is very familiar with the type of oversight work we're doing here today from her time as investigative counsel with the House Oversight and Government Reform Committee. Welcome, Ms. Guliani.
Thank you. Chairman Paul, Ranking Member Peters, and members of the subcommittee, thank you for the opportunity to testify today, and thank you for your leadership on this important issue. Each year, tens of thousands of individuals are subject to invasive and often humiliating searches of their electronic devices at the border without a warrant based on probable cause. One of these individuals is Diane May, a former Air Force captain and current professor of Homeland Security and Global Conflict Issues. She is also a plaintiff in an ongoing case brought by the ACLU and the Electronic Frontier Foundation. In June 2017, Professor May was traveling to Miami when she was detained by CBP officers upon arrival. She was escorted into a small room where CBP officers seized her smartphone and her laptop. Because she had no meaningful choice, Professor May unlocked both devices and watched as officers searched her laptop, and later as they confiscated her unlocked phone for approximately 2 hours. In describing her experience, Professor May has said, quote, "I felt humiliated and violated. This was my life, and a border officer held it in the palm of his hand." In yet another case, Ghassan and Nadia Al-Assad, who were also plaintiffs in the same case, were returning home from a family vacation when their entire family was detained by CBP, including their ill 11-year-old daughter. Upon arrival, they were directed to secondary inspection, where CBP officers questioned Mr. Al-Assad and searched through his unlocked phone. The CBP officers later requested that Ms. Al-Assad turn over her cell phone password. The couple refused, in particular because Ms. Al-Assad wears a headscarf in accordance with her religious beliefs, and her cell phone contained pictures of her without her headscarf, which she did not want CBP officers, particularly male officers, to view. The CBP officers explained that a failure to turn over the password and comply would result in Ms. Al-Assad's phone being confiscated. Because they had no meaningful choice, the Al-Assads provided the password. There are countless other examples, many which raise the additional concern that individuals are being improperly targeted based on their religion, political beliefs, or other impermissible factors. As Professor Donahue noted in her earlier remarks, the number of these searches has soared to over 30,000 in 2017, representing a 3.5-time increase from 2015. DHS violates the Constitution by engaging in these warrantless device searches, wrongly arguing that they fall under the border search exception to the Fourth Amendment's warrant requirement. These searches do not comport with the Fourth Amendment, as recent Supreme Court jurisprudence makes clear. The Supreme Court's unanimous Riley decision made clear that traditional exceptions to the Fourth Amendment's warrant requirement do not automatically extend to searches of digital devices. In its decision, the court highlighted the volume and sensitivity of information stored on these devices, noting that it will allow someone to reconstruct the sum of an individual's private life. This term, in Carpenter, a case argued by the ACLU, the Supreme Court also ruled that historical cell phone location information was subject to the Fourth Amendment's warrant requirement. Similar information can often be gleaned from a device search. Indeed, several courts have rejected the government's claim that the border search exception places no limit on device searches at the border. The Fourth Circuit has recognized that a forensic search of an electronic device at the border requires some level of individualized suspicion, though it declined to address whether a warrant or probable cause is required. As this issue is litigated, however, thousands continue to have their rights violated. That is why it's important that Congress swiftly pass legislation, including the Protecting Data at the Borders Act, sponsored by Senator Paul, Senator Wyden, and others. Congress should make clear that a warrant is required for all searches of the content of electronic devices, that travelers are not under an obligation to unlock or provide device passwords, and that individuals cannot be unreasonably detained for failing to consent to a search or unlock their device. Until such legislation is passed, Congress should press CBP to release new guidance that contains the following 4 improvements. 1, the guidance should require a warrant in any case where the government seeks to search the content of a device. Current policy requires no suspicion for so-called basic searches and only reasonable suspicion for advanced searches. 2, the guidance should narrow the permissible purposes of the search. CBP should be prohibited from conducting searches at the request of or to assist other agencies. The guidance should also not allow suspicionless searches when there is vague so-called national security concerns. Such language as vague could be interpreted as applying in cases where an individual poses no imminent threat and increases the likelihood of discriminatory and arbitrary application. 3, the guidance should be amended to make crystal clear that travelers are not obligated to turn over their device passwords, and it should prohibit unreasonably detaining individuals for failure to take such action. And finally, the CBP guidance should apply to all DHS components, including ICE, which maintains its 2009 policy, which has even fewer protections. Again, thank you for your leadership on this issue, and I look forward to answering any questions you may have.
Thank you. Thank you for your testimony. Our next witness is Matthew Feeney. He's the director of Cato Institute's Project on Emerging Technologies, where he focuses on the intersection of new technologies and civil liberties. He was previously an assistant editor at Reason.com and a writer at the American Conservative and the Institute of Economic Affairs. Welcome, Mr. Feeney.
Thank you, Chairman Paul, Ranking Members Peters, and members of the subcommittee. Thank you for the opportunity to speak with you today about an important topic that I think should concern every American. In Riley v. California, the U.S. Supreme Court recognized that searches of cell phones implicate privacy concerns beyond those associated with searches of wallets, cigarette packs, and other everyday items. Writing the Riley majority opinion, Chief Justice Roberts stated that the government's claim that the search of a cell phone and the search of a wallet are materially indistinguishable is like saying a ride on horseback is materially indistinguishable from a flight to the moon. Roberts was correct. Our cell phones contain troves of revealing information about our personal relationships, careers, religious affiliations, and hobbies. It's no exaggeration to say that unfettered access to a cell phone allows investigators to uncover details about almost every intimate communication and relationship associated with the owner of that cell phone. Officials with access to cell phones can easily view photos, calendars, email accounts, social media postings, and other revealing data. Riley's holding that police need a warrant to search phones belonging to arrested persons recognizes that the privacy interests American adults have in the content of cell phones. Despite Riley, as we've already discussed, cell phones and other electronic devices enjoy reduced protections at the border, thanks to the Fourth Amendment's border exception. The Supreme Court has yet to consider the constitutionality of warrantless searches of electronic devices at the border. However, Congress can extend the Riley standard to the border via legislation. And although the warrantless search of electronic devices affect a minority of travelers, the number of these searches has been increasing, almost 60% between fiscal year 2016 and fiscal year 2017. A 2009 CBP directive on electronic device searches stated, in the course of a border search, with or without individualized suspicion, an officer may examine electronic devices and may review and analyze the information encountered at the border. A 2018 directive improved the 2009 directive, but not enough. The latest directive distinguishes between basic and advanced searches. Under current DHS policy, a search of an electronic device that doesn't involve an officer connecting the device to external investigatory equipment is a basic search. Basic searches do not require suspicion, which is required for so-called advanced searches. The new directive includes a worrying provision that allows officers to examine a phone with external equipment if there is a, quote, national security concern. This is especially worrying because the directive notes that the presence of an individual on a government-operated and government-vetted terrorist watch list creates reasonable suspicion. Government watch lists, however, do not only include terrorists. Officials have placed law-abiding Americans on watch lists designed to prevent dangerous people from flying. The 2018 directive also requires travelers to unlock their phones. CBP officers have compelled American citizens to unlock and hand over their phones, even after being told that the phone contains sensitive data, such as those belonging to NASA's Jet Propulsion Laboratory. According to the latest directive, officers conducting a search must either have the travelers disable network connectivity or disable the connection themselves by, for example, putting the phone into airplane mode. But these policies are of little reassurance to travelers. Even in airplane mode, cell phones contain revealing information. Text messages, emails, photos, browsing histories, videos, and calendars are still available to officers examining a cell phone in airplane mode. In addition, cell phones in airplane mode do not conceal apps that the cell phone owners may use. You hardly need to have a phone connected to a network to uncover information about someone who has downloaded the Muslim Pro, Coinbase, or Tinder apps. Current DHS policy does not do enough to protect travelers' civil liberties. However, bills proposed by the chairman as well as Senator Leahy do improve the CBP 2018 directive. A welcome provision of the Senator Wyden and Senator Paul bill is the warrant requirement for cell phone searches. The Leahy bill would also improve the status quo by requiring increased transparency. DHS has not published figures showing how many of these warrantless searches have contributed to terrorism or child pornography-related convictions. Such data would be welcome, as it would allow the public to better assess the efficiency of warrantless searches that endanger their privacy. As has been discussed, some U.S. courts of appeals have considered questions concerning the standard of suspicion that should be necessary. However, as things stand, there is no consensus. Until the Supreme Court addresses this issue, lawmakers can provide CBP with requirements that go beyond the unsatisfying directive issued by the Department of Homeland Security. Again, thank you for your attention to this important matter and for the opportunity to testify before you. I look forward to answering any questions you may have.
Thank you very much. Thank all of you for your testimony. When I first heard about this, and I heard that it would be possible that an American citizen could leave the country and come back and be denied entry into their own country unless they give their password up, I was horrified by this, and so I very quickly called my colleague Ron Wyden and said, we got to do something about this. And so there's an array of people on both sides of the aisle who I think want to fix this. The one question I have is a little more of a tricky question and goes to the fine point of things and may not bring us all into an agreement, but there's sometimes a debate over who the Constitution applies to. I think most people who read the Constitution realize it applies to everybody in the United States, all persons. Fifth Amendment, Sixth Amendment, you get a trial whether you're here legally, illegally, whatever your status is, you get a lawyer, a trial, jury trial. It's a little bit different maybe at the border, and I think I could allow for a little bit of differences between citizens and U.S. persons and maybe those who are visiting. And that's the question I throw out. Do you think it's possible that you could? So, for example, one of the gentlemen that got had his phone taken was in the Trusted Traveler program. Frankly, once you get in that program, if it's worth what it's supposed to be worth, you probably should be going through much easier than other people, and maybe somebody who's not in the Trusted Traveler program might get searched more often, randomly or otherwise, and that there might be different thresholds for people based a little bit maybe on citizenship and U.S. personhood versus I bought my ticket yesterday and I'm coming from an area where there's, a lot of terrorism. Could we ask more questions or have a lower level, or would we have a warrant requirement for everybody? And so I guess I throw that question out to the panel on citizenship, whether the rules have to be exactly the same or at the border we might have a gradation based on citizenship versus non-citizenship. Yes.
Yes, so thank you. I would distinguish here between law and policy. So as a matter of constitutional law, the Fourth Amendment, in 1990, Chief Justice Rehnquist ruled in a case called Verdugo-Urquidez that the Fourth Amendment does not apply to non-citizens who lack a substantial connection to the United States. And the reasoning that he had in that case, as well as Kennedy's concurrence in that case, which is slightly different, from Chief Justice Rehnquist, but his reasoning was that the right of the people to be secure in their persons, houses, papers, and effects, as Ranking Member Peters quoted us the Fourth Amendment. It's the same people that are the people in the Constitution. Therefore, the Fourth Amendment does not apply. And this might explain the difference between CBP's provisions, which come from a customs background applied as to U.S. persons, as opposed to immigration provisions in Title 19, which apply then to aliens and non-U.S. persons. With that said, in the last hearing that you had on this in 2017, there was a really interesting discussion. And at that point, Senator McCaskill noted that if she were visiting another country and were asked at that point to turn over your social media password, your mobile phones, all of your records, that this could cause significant foreign affairs and national security concerns. So she said, if my family was traveling to the United Kingdom and they told me we would have to answer questions about my beliefs, we would not go. This will have a profound impact on our standing in the world, a profound impact on the nature of our alliances around the world, and a profound impact on our national security. So while as a matter of law, many of these, there might be a line to be drawn, and that I'm happy to speak to as a con law person, but as a matter of policy, that's something that Congress would have to take on board.
Right. And I think the one response I would have to that is that while you have to have scrutiny and you want protection, you also want to find ways that make it a friendly place to visit. That's why I'm actually a big believer in some of the trusted traveler programs, the frequent flyer programs. Let's try to do background scrutiny on people so they go through the airports much easier and they don't feel oppressed. And I don't care, you could be from any country in the world. If you've gone through it and we've screened you, I think we could get that. I really think we need to extend the trusted travel program to the whole world. And even these countries where we so-called are banning people now, let people go through it who are legitimate businessmen and women or academics or physicians or whatever, or that have legitimate reasons. And I think we could probably obviate some of the problem we have, because you're right. Who would want to go to a country where they're going to take your cell phone from you? But on the other hand, we do have to worry about people coming here who might attack us. But I think without question that the American citizen and U.S. person should be protected by the Fourth Amendment when they come back home. Did either of y'all?
Yeah, I think there are strong arguments in favor of applying a warrant standard to U.S. persons and non-U.S. persons. In addition to the reciprocity issue, how we treat non-U.S. persons when they arrive here is how we may be treated abroad. We have to recognize that the searches of these devices implicate not just the privacy of the person who owns that phone, but potentially thousands of others, right? Their family members, their associates. When you're talking about, let's say, business travelers, they may have emails and other content that implicates the privacy of individuals inside the U.S. So we're talking about an enormous privacy violation, and we're talking about searches that at the outset are really quite attenuated from searching for contraband like you might do in luggage or admissibility. And so for that reason, I think the right policy outcome is a strong standard that applies to both U.S. citizens as well as travelers.
I suppose it's difficult for me to give an unbiased opinion on this, given I became an American citizen deliberately and happily after, well, retaining my British citizenship. I would note that I think the proposed legislation proposed by Senators Wyden and Mr. Chairman and Senator Leahy are all improvements on the status quo. But I think that what Nima and Laura mentioned is right, that maybe purely in the foreign policy realm, that it's good for our foreign policy to extend protections because we should be wary of how American citizens will be treated when they travel abroad.